morning to each one of you. On behalf of the Bangalore Chamber of Business and Commerce, we welcome each one of you to this webinar on arbitration landscape, measures to promote alternative dispute resolution. This session has been organized under the aegis of Banking, Finance and Corporate Expert Committee of Bcic. We would like to specially thank Dr. K.V. Omprakash, Chairman of the committee, and Advocate and Founder Director, Consortia Consultancy, and Mr. Venkatakrishnan N, Mentor of the committee and Executive Vice President and CFO, Tata Hitachi Construction Machinery and Company. And also Dr. K.S. Ravichandran, Member of the committee and Managing Partner, KSR & Co., for curating this session for the benefit of our members. The speakers for today's session are former Justice Sri N. Kumar and former Srimati Roshan Dalvi. The session is being moderated by Dr. K.V. Omprakash, Chairman of the Banking, Finance and Corporate Affairs Expert Committee, BCIC. On behalf of the BCIC, we express our sincere thanks to former Justice Sri N. Kumar and former Srimati Roshan Dalvi for accepting our invitation on this important subject. We'd also like to acknowledge and thank KSR & Co. for having been a supporting partner for this today's session. We also would like to thank all the participants for joining in today's session, being on a Saturday. We request all of you to kindly mute your mics and webcam options. This is to enhance and keep the bandwidth strong, as well as avoid any disturbance in the background. Please post your questions in the chat box only. The speakers will respond to the question during the session, and in case time do not permit, we shall share the queries to the speakers and shall revert back accordingly. May I now invite Dr. K.V. Omprakash to share the context for today's subject and also moderate the session. Thanking you once again to all. Over to you, Dr. Omprakash.
Welcome all. A very good morning, happy good morning, and I sincerely thank former Justice Sri N. Kumar for having accepted our invitation, and also former Justice Srimati Roshan Dalvi to having accepted our invitation for this session on the arbitration. We will be much thankful if you can throw light on the importance of arbitration and various nitty-gritties so that our members are benefited. Today, BCICI is also in the process of forming a mediation center and arbitration center. So we would be very thankful if you, with your guidance, we will start off with this session. And thank all the members for joining us. And I now request Dr. K.S. set the context, the background of the meeting and the topic. On to you, KSR.
A very good morning to all of you. My special thanks to Justice N. Kumar. So kind enough, you will not believe, just I have texted him over WhatsApp. He was readily agreeing, and I know that he has handled several matters and is an expert in the Civil Procedure Code, and he has kindly accepted our invitation to give us some thoughts, some of his thoughts, because the time constraints, he may not be able to do everything, but he will do justice within the given time. To give us some idea of the principles which are definitely the backbone of adjudication or dispute resolution by arbitral tribunals. And similarly, we have the great advantage of the presence of Justice Roshan Dalvi. I had some experience of, having an arbitration matter appearing before her in Mumbai. It was she is regarded as most efficient judge during her days, disposing several cases. And the numbers are probably entitled to be recorded in the Guinness Book. And that is how I know. And she has also kindly consented at the invitation of BCIC to give us a background of the arbitral scenario, the landscape, rules, etc. And it will be very great for us to limit our speech and leave it to the experts, the speakers, because after the 2015 amendment and the 2019 amendment and the ordinance, very fine amendments have been made. Whether you take 34 or you take even 28 or you take 36, small amendments, but have far-reaching consequences in terms of pleadings. If you want to say, you want to ask some trade usages, you must plead that this is the trade usage. You want to say that there is a fraud, corruption, or any other thing, you must plead it. From the records of the tribunal, it should be there. That is why there is a very subtle amendment in section 34. I think we have BCIC has taken up the cause of spreading awareness on the ADR, so much so even under the Companies Act, the government has thought it fit to introduce section 442 so that there is mediation and conciliation which is given precedence instead of long drawn battles from one tribunal to appellate tribunal to Supreme Court. With this brief introduction, once again I thank Justice N. Kumar as well as Justice Roshan Dalvi for having kindly consented to address us here. Over to Om Prakash. Thank you, sir. Thank you, madam.
Thank you, KSR, for this setting the context and also giving the importance of the amendment. May I call Dr. Shrikant Parsadi to introduce former Justice N. Kumar?
Indeed, my privilege to introduce Dr. Kumar, sitting in his office actually, and having presence with him. It's a very wide presence that I have with him. So that being said, I would just, if I read out his resume or his biodata, it will run to pages and pages with his accomplishments. So just a few points so that I give time to hear from the learned justice. Justice Kumar is a doctorate, honorary doctorate from the Alliance University. He has been chairperson of the National Law School University. He was the president of the Karnataka Judicial Academy, and more importantly, a Rajyotsava awardee, which is indeed a pride that we are sitting in Bangalore and addressing a Rajyotsava awardee. So that being said, he has been in the judicial field, or he has been a judge for 16.5 years. So you can understand what is the immense knowledge that he carries and the persona that he carries. It is indeed my honor to welcome Dr. Kumar, Justice Kumar, and I look forward to this session.
Thank you, Dr. Shrikant Parsadi. And now may I call upon former Justice N. Kumar to give his insight on CPAC as applicable to arbitration. Sir, the floor is yours, sir.
Very good morning to all of you. I take it that I'm addressing the personalities who are in the commercial field.
Correct.
CPAC is applicable to several fields. Now I confine it to only commercial field because they are more worried about CPAC than anybody else. See, economic growth, increase the foreign investments, make India an attractive place to do business. Now that is well felt. It is also necessary for such economic development a robust dispute resolution mechanism is a sine qua non for the all-round development of an economy. Today we are talking about making India an economic superpower. Therefore, it is of utmost importance today that everybody should keep that in mind. Not his case, the interest of the country. And the world is watching us. In India, now it is well settled. Access to justice and a speedy trial is a fundamental right of the citizen of this country. And that right also applies to commercial establishments and people who are in commerce. Now, in order to achieve this object, what the government and the parliament of this country has done is, we had the original course dealing with suits, commercial disputes. Now that they thought there's a delay in disposal of cases and these commercial disputes should be put on a fast track. Today we have what is known as a Commercial Courts Act in place, dealing exclusively with commercial disputes. In addition to that, before the passing of this Commercial Disputes Act, Commercial Courts Act, it was felt the procedural law of the land, the CPC, is coming in the way of speedy disposal of commercial disputes. And therefore, we thought of alternative dispute resolution mechanisms. One such mechanism agreed upon is the arbitration. And therefore, the earlier 1940 Arbitration Act was repealed. And on the basis of the unilateral law, the Indian Parliament enacted the Arbitration and Conciliation Act of 1986. Because it was found, though the procedural law was extensively amended in the year 1976, according to the people in the commercial field, that was not sufficient for disposal of commercial disputes expeditiously. And therefore, this Arbitration Act of 1986 was passed. Well, even after the 1986 Arbitration Act, because of various factors, the desired effect you could not achieve. And therefore, the Arbitration Act is also amended in 2015 and recently in 2019. In between, we have the Commercial Courts Act. Now, the option that is open to the people in the commercial field is, what is that you want? You want a speedy disposal of commercial disputes. Today, you have two options: opt for arbitration and opt for dispute resolution in the commercial courts. Now, the difference between the two is, in the case of commercial courts, you have no choice of a judge. There are several commercial courts established throughout the country, and the matter is assigned to a particular commercial court. Whether you like the judge or not, you have to take a decision in his hands. On the contrary, if you want a satisfactory, speedy disposal, you have the option of availing the remedy of arbitration. There you have the freedom to select a judge of your choice. In the sense, you have his past record of integrity, efficiency, knowledge of law, and experienced man. He is not going to gain experience at your cost, as in the case of courts. Here is an experienced man who will give his experience. Even if sometimes the lawyers are not quite experienced, the arbitrator comes to the aid and sees justice is done. And the procedure to be followed in the arbitration also is to be decided by the parties of the arbitrator. That is the object of the whole Arbitration Act. Now, coming to the question of principles of CPC as applicable to arbitration is concerned. Well, personally, I feel there is nothing wrong with the CPC. It is the application of CPC by the judges and the lawyers to all the problems. CPC by itself is the best legislation one can think of. So what is the principle underlying the CPC? If you remove the CPC laws, then we fall back upon what is known as justice and fair play. Justice and fair play. That's what the people want. And that is based on what is known as principles of natural justice. You must hear a person before you condemn him. If you want to pass an adverse order, hear him and pass an order. Don't be afraid of passing an adverse order. But you must hear him and patiently hear him, give him a full opportunity, and then pass an order. This is the second principle, which is embodied in the CPC itself. And both the parties should have an opportunity to plead their case to their satisfaction and support their case by both oral and documentary evidence. And the opposite party should have a right to cross-examine those witnesses. This is said to be the foundation of a good trial. Then, of course, here the arguments, substantive law is there. and then on the basis of the material on record with the members of the bar address arguments. Under the old law, an arbitrator was not expected to give any reasons at all. Therefore, everybody thought arbitration is very important. Either say yes or no. Having seen the experience in the past under the 1940 Act, today in 1986 Act, a specific provision is made saying arbitration award should be a reasoned award. Only if the parties say, I don't want reason, tell me yes or no, the arbitrator can say. Otherwise, it should be a reasoned award as a judgment and decree of a court. So this is basically the principles embodied in the CPC, which is also followed in the arbitration cases. Now here, let me tell you, everybody is blaming the CPC. The judges, the lawyers, the litigants, the politicians, common man. Now, if you want speedy justice, what is it you are expected to do? You should not ask for adjournment, is it not so? Everybody is complaining about opposite party asking adjournment. Nobody is finding fault with them for not asking adjournment. If you are the person who has come to court, you want speedy justice. And if you are in the opposite party, you want to drag on the proceedings. How is it possible? And you instruct your lawyer to take time. You create all sorts of problems in the court so that the matter will not go on. See, this is the sum and substance of our litigation. And without knowing this, everybody is blaming the law. Now, all right, law is blamed. Parliament believed all of you, and Parliament has amended the law as you wanted. And how are you conducting yourself? In 1976, a substantial amendments were to the procedure code. When they said there is a delay in disposal of civil cases. What is that amendment said? Till today, nobody has opened their eyes. What that amendment said was how a case is to be conducted. Order 17 of the Civil Procedure Code dealt with adjournments. Everybody read only the title and they thought that is a provision which gives you adjournments. It is that provision which was substantially amended in 1976. What they said in that provision is, please read this, even to this day, even in the arbitration court or the commercial court, this provision is not followed. What they said was, when the hearing of the suit has commenced, it shall be continued from day to day until all the witnesses in attendance have been examined, unless the court finds that for the exceptional reasons to be recorded by it, the adjournment of the hearing beyond the following day is necessary. You cannot think of a fast trial than this. They said it should be day to day. If for any reason it can't be adjourned to tomorrow, if you want to adjourn it to day after tomorrow, judge has to give reason why is he adjourning it. They did not stop there. They said in what cases adjournment should not be given. No adjournment shall be granted at the request of a party, except where circumstances are beyond the control of the party. Beyond the control of the party. So the rule is no adjournment. Rule is day-to-day trial. See, the fact that the pleader of a party is engaged in another court shall not be a ground for adjournment. Today, 99% of the cases in courts, the case is adjourned on the ground, the senior counsel is in another court. A senior counsel is engaged in 100 cases. He can't be in 100 courts. Knowing that, they said that a counsel is engaged in another court is not a ground. They will say he is on his heels. You can't be on your head. You have to be on the heels. And that is not a ground for adjournment. That is not a ground for adjournment. Whereas the illness of a pleader or his inability to conduct the case for any reason other than his being engaged in another court is put forward as a ground for adjournment, the court shall not grant the adjournment unless it is satisfied that the party applying for adjournment would not have engaged another pleader in time. Illness of a counsel is not a ground. Marriage in his house is not a ground. Because he is engaged in a meeting is not a ground. That's what the law. In practice, what are you doing? He said, the doctor has given me an appointment 3 months afterwards for a heart surgery. Grant me adjournment today. So 3 months prior heart operation, after 3 months, no adjournment. The case will not go on. And the functions will be in the house, marriage. So many functions will be on. Is it a ground? And then my driver is not well. My driver's wife is not well. Therefore, he has not come. Therefore, I can't come. What is all this? And you are blaming the CPC. CPC says no adjournment. It is set in 1976, 20 years before the Arbitration Act came into force. Then, sometimes the lawyers are very intelligent. What they used to do is, especially in Mafuzal area, they will give the lawyer their court. They will give the lawyer their file. Ask him to go and stand in the court and tell the judge, my lawyer is coming, his court is here, his file is here. For that they said, where a witness is present in court, but a party or his pleader is not present, or the party or his pleader, though present in court, is not ready to examine or cross-examine the witnesses, the court may, if it thinks fit, record the statement of the witness and pass such orders as it thinks fit, dispensing with the examiner-in-chief or cross-examine the witness as the case may be by the party or his pleader not present or not ready as aforesaid. This is the power given to the court. If any judge were to exercise this power, the Advocate Association will pass a resolution saying he is prejudiced. He has interest in the case. He is not waiting for the advocate. He is not waiting for the party. He is tortured. The law gives him the right. If he follows the law, he is in trouble. Party doesn't want to follow the law. The advocate doesn't want to follow the law. If the lawyer, judge follows the law, he is in serious trouble. So this is the CPC in 1976. And still you are breaking the CPC. Then they brought in this 1996 Act. It is according to unilateral law, international standards. What is that international standard they are talking about? And everybody's eyes is on this poor CPC. So what they said was, in this 1996 Act, please see, it's an insult to the CPC. They said, how should the arbitral proceedings should be conducted? They said equal treatment of parties. In the court, equal treatment is not given. The parties shall be treated with equality, and each party shall be given a full opportunity to present his case. Are you saying that in court you have no opportunity? It is too much opportunity. It is the root cause of this problem. This is the most insulting provision in this arbitration. Fine. Then they said, CPC is bad, is it not so? Therefore, what you should do? The arbitral tribunal shall not be bound by the Code of Civil Procedure. So don't follow civil procedure. Fine. Or the Indian Evidence Act. Don't follow Indian Evidence Act, don't follow civil procedure. You exclude that, there is nothing else in this world. All right. After excluding it, what is that you have said in the Arbitration Act? Subject to this part, the parties are free to agree on procedure to be followed by the arbitral tribunal in conducting its proceedings. To my knowledge, in one case, parties have not said what is the procedure they want to follow. They simply put it on the arbitrator. Who is the arbitrator? He is a product of the Indian judicial system. He has been brought up in the civil procedure code only. How can he have any other procedure? Therefore, the law said, failing an agreement referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceedings in the manner it considers appropriate. If a judge has been in the judiciary for 20, 30 years, the civil procedure code will be in his blood. He can't be different. What is that civil procedure code? Give a patient hearing. Give them full opportunity. Conduct the case with an open mind. Don't have any preconceived notions. Carefully look into oral and documentary evidence. Give reasons when you are agreeing or not agreeing with any argument. Write a reasoned order. This is the product of CPC. So they don't want CPC. They don't want Evidence Act. So again they are saying either the parties will decide the procedure or the arbitrator will decide the procedure. Having said that, please see where it ends. The power of the arbitral tribunal under subsection 3 includes the power to determine the admissibility, relevancy, materiality, and weight of any evidence. You don't want Evidence Act, but where do you get all this? Admissible in evidence. What is relevant to this case? You are leading so much evidence. What is the relevancy? And they say material particulars to be pleaded, material facts to be set out, and material has to be produced before the court. And then what is called as burden of proof. That is why I call it weight. You may use different words, but the meaning is the same thing. So they don't want CPC, they don't want Evidence Act, and this is what they want. From where do you get it? Now, coming to the place of jurisdiction, there is a lot of trouble in the CPC. Where the cause of action arises, where the property is situated, where the defendant resides. That has been made very liberal. Now, as far as place of arbitration is concerned, I would say this is a great step. They said parties are free to agree on the place of arbitration. Not now, earlier, because of this provision, probably, even without this provision, arbitrator used to have arbitration sitting once in Manali, another in Simla, another in You understand? This is the provision you are saying. If properly interpreted, in summer, we can go to hill stations. Are free to agree on the place of arbitration. Though the provision, earlier it was not there, now they have specifically put it. Failing any agreement, referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal with regard to the circumstance of the case, including the convenience of the parties. See, the principle of jurisdiction was the jurisdiction is to be decided in the light of section 60 to 20 of the Civil Procedure Code, where the defendant resides, where the property is situated, where the cause of action arose. That has been agreed. Now this, and we also said parties by consent cannot confer jurisdiction. Jurisdiction is conferred under a statute. Now that principle is given a go by. Parties by agreement can decide the place of arbitration. So therefore, it's left to the complete convenience, because ultimate object is we want speedy disposal. The object is speedy disposal. You are choosing a place should not come in the way of speedy disposal. So therefore, they gave them full freedom. So that, to that extent, CPC is overruled by this provision. Now, regarding the commencement of the proceedings, please see the provision. What is the object and what has happened? They said, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commences on the date on which the request for the dispute is to be referred to arbitration is received by the. In the civil case, it is the date on which the suit is filed. That is the day on which the proceedings commence. There will be exchange of notices. Now, under the arbitration law, they said the moment you make known your intention, issue a notice and say, I have appointed an arbitrator, the arbitration proceedings commence. As far as language is concerned, there is no problem, it's left to them. Now, the object is this. Earlier in the Civil Procedure Code, after the suit summons are issued, they used to take 2 years for service. After appearance, an application is to be filed for calling for particulars, application, objection, hearing, that 1 year, against which an order to the High Court stay. That's how the proceedings were stayed. Now, amendments were brought to say that provision itself is completely now deleted. Now they said the moment the summons is served, within 30 days therefrom, the return statement is to be filed. The maximum time to which it could be extended is another 90 days. So within 120 days, the pleadings have to be completed. That provision was abused. Now in the 2015 amendment, which applies to commercial courts, you see what they have done? They said if you don't file your objections within 120 days, your right to file the defense is forfeited. But the court said we have the power. No, they said you court also doesn't have the power to entertain it. It is because when judges and lawyers and parties did not rise to the occasion, did not understand the principle behind these amendments, and in the garb of exercising discretion, now the law has come and said court has no right to receive it. and your right is forfeited and pass an order. It's not a good thing as far as courts and lawyers are concerned. No, you are controlled by law. You had the discretion. You abuse the discretion. And today all the amendments are to that effect, taking away the decision of the court, taking away the right of the lawyer and the party. So therefore today, now this is the position as far as commercial courts. What's happening in arbitration? I said claim in 6 weeks, objections in another 6 weeks. CPC says pleadings means plaintiff and return statement. In arbitration we have started a new development. Rejoinder and reply to the rejoinder. Pleadings means only plea. Now the pleadings in the arbitration consists of, I have to search for the plea. Documents are extracted. Contents of the letters are extracted. Statutory provisions are extracted. Judgments of the courts are extracted. Therefore, it is about 400 pages. Maybe it's good for the lawyers. Depending upon the number of pages, we can fix our fee as far as reading fees is concerned. That is not the object. You will never know what the case is. If you want a speedy disposal from a judge, have sympathy to the judge, be straightforward and simple, tell what your case is. Afterwards, objection statement. There is 2 files. 400 pages denial. Another 400 pages, they will say what their case is. So it becomes 800 pages. And again, rejoinder, another 400 pages. Where is the end? Books. We have to number the books 1 to 20. It has become a mockery. And this is not done by a poor farmer, a poor worker. These commercial disputes are industrialists who are talking about Indian economy, who wants to be disposal. And this litigation is coming in the way of economic development of the country. I am glad that you are holding these seminars. It should be purposeful. They should know where the mistake is. Maybe one of the grievances of the lawyer is, if I put pleadings of 20 pages, I may not get a proper fee. If it is 400 rupees, I will get a fee. Then you have to change your attitude. If the lawyer's fee is to be fixed on the number of pages of the pleading, it goes on increasing. You want justice, you want dispute resolution, or you want this tamasha which is going on in the name of arbitration. And I have to have higher accommodation to keep these files. So much the papers which are given in the arbitration. This is not the object of the Arbitration Act. This is not what the universal law says. And you are blaming the CPC, and the procedure which is followed in arbitration is worse than that. Now, in the arbitration cases, on the first hearing, we used to fix a schedule. Claim statement to be filed within this date. Objection should be filed within this date. Reply within this date. If there is a counterclaim, defense so and so. Then discovery of documents. Then admission of documents. Then framing of issues. Filing of affidavits by way of affidavit. Cross-examination on such a date. Written arguments. Oral arguments. A schedule was fixed. I don't know anybody has adhered to that. One reason, the entire schedule got upset. Now see the development. Commercial Courts Act today has taken this clue from the Arbitration Act, and now they have made it compulsory that the court must have, the commercial court should have this schedule. And similarly it is fixed. Now the point is not that there is any weakness in the law. Law, according to me, whether you take it CPC, whether you take it 1996 Arbitration Act with amendment of 2015 and or 2019 or Commercial Courts. Now CPC is amended keeping in mind the Commercial Courts Act, which is not applicable to other cases. So read between this Arbitration Act amendments and the Commercial Courts Act. If the parties cooperate, they could reduce the duration of the litigation and have disposed of matters within a month. There is no attempt. Now the Commercial Courts Act has realized this mischief. A provision is introduced, and I am sure it should be applicable even to Arbitration Act. If you write things which are not relevant in the affidavit, because affidavit is nothing but a translation of pleadings into affidavit. Now power is given to the commercial courts to return it. Or take a pencil and strike out all irrelevant matters and see that It is confined only to the facts. So, when we are talking about the principles of CPSC in arbitration, the law has not changed. Because of a particular procedure followed in these cases, these amendments have come into existence. However good, beyond this, there cannot be any more amendment. According to me, we have reached a dead end. I have the experience when lawyers cooperated with me, in 3 days I have finished cases. 1 day petitioner's evidence, 2nd day respondent's evidence, 3rd day argument, within a week we have finished it. And 11 to 5 I am free. Question is how you make it free. Especially the people in the commercial world. It depends upon the instruction you are going to the lawyer. To drag on, he will drag on. Speed it. And you must also assist him in preparing these defenses, making available the documents. It is not just so in the CPC. And we have a provision called admission and denial. If you admit, a big galata, say cost. They say document receipt is admitted, contents disputed. You need not design the consent. Question is, did you receive that document? Contents, you need not accept it. Nobody can say you have accepted it. When I read the correspondence for a period of 3 years, I can make out what is the dispute. It is not necessary for you to admit or deny it. See, these are all simple things. And for that, a big affidavit is fine. I am fed up with this reading. Affidavits are affidavits, documents after documents, and in the end of the day, we will not know what is the point in controls. So my suggestion to the people in the commercial field is, if you are really interested in speedy disposal, satisfactory disposal of cases, first you should make up your mind. You should instruct your lawyer accordingly. And the effort of both of you should be to assist the arbitrator in finding out what the matter in dispute and doing justice, not to confuse the arbitrator, not to create problem for the corporate. Then wait and see what the arbitrator will do. See, the whole lawyer is an officer of the court. Without his assistance, no justice can be done. So the attempt should be to assist in rendering justice, not confusing. Thoroughly approach is totally different. That's my grievance. Therefore, when you are talking about CPC and its impact in the Arbitration Act is concerned, either you follow CPC, either you follow any procedure in the arbitration, or you follow this commercial court's law, it makes no difference unless you are competent. You are capable of implementing these provisions. The provision by itself is of no use. Attempt should be to speedy disposal. I've seen the people, if they are the claimants, their attitude is different. If they are opposite party, their attitude is different. How is it possible? In one case, you will be a claimant, in another case, you will be a respondent. Business has to go on. If you have to pay some money to somebody else, you have to pay. If you don't, if you have to get it, you have to get it. And this litigation is not one. If you are in a business for 40 years, you will see so many litigations. Without litigation, there cannot be any commercial activity because of various factors, in particular to India. Now, you are talking about Section 34. The 34 was the subject matter of a judgment of the Supreme Court. Therefore, 10 years arbitration came to a standstill. Now they have made some improvements. Still, I don't know where we end. But one of the factors which I appeal to the members of the business community, you choose the lawyer, judge, an experienced man, an honest man, and why do you take it from me? No judgment rendered by any judge in this country or anywhere in the world can be 100% correct. We are all human beings. There will be some errors, and the lawyers will have the binocular to find out those mistakes. Then there is no end to this litigation. There is bound to be some errors here and there. Question is whether substantial justice has been done. If you want to be a businessman, are you going to spend your time in before arbitrator? Courts are in the business. If this attitude doesn't change, I see all this is a failure. And therefore, arbitration is there, Commercial Courts Act is there, everything is fine. But the attitude of the litigant should change. Attitude of the lawyer should change. If that doesn't change, these amendments in the law will not take us too far. Will not take us too far. And we are doing the same thing what we are doing in the court in the arbitration also. Then what is the difference? Arbitration should make a difference. You have an experienced arbitrator, experienced lawyers who appear, and no case is 100% correct. There are some defects here, there are some defects there. Question is, where does the justice lie? What is the substantial justice to be done? And that is done in a better way in an arbitration proceedings, and it is a speedy disposal. And if you think only let the arbitrator do whatever he wants, we have the remedy by way of 34, we have the remedy by way of 37, then there is no difference. Yes, remedy by way of 34, 37 is there. Question is it necessary to invoke that jurisdiction in every case? That's where the discretion, maturity of the lawyer and the clients would provide. If you want to invoke all those provisions and go up to Supreme Court, it makes no difference whether in a commercial court or before an arbitration court. And therefore, ultimately, it is for you. As far as the law in India is concerned, it is perfect. According to me, it is flawless. The problem is, it is implementation. It is in an understanding. For what purpose you are making use of this law? And you can continue to blame CPC, but there is no substitute for CPC. You have to work within that. And I do not see any reason where the procedural law of the land is coming in the way of either disposal of cases in civil court or before an arbitration. Anyhow, time is up, therefore I stop here. If there are any questions, I don't mind.
Om Prakash, unmute, please.
Thank you very much, former Justice N. Kumar. You have really given us the insight about the amendments and also the importance of arbitration for the business community here who are watching you, and the various methods of adjourning and all those intrinsic tricks which only the advocates know. And thank you very much. And definitely the question answer sessions will follow after former Justice Roshan Dalvi finishes her topic as well. And I call upon Dr. K.S. Ravichandran to introduce former Justice Srimati Roshan Dalvi.
A very good morning once again. Justice Roshan Dalvi is a Bachelor of Commerce and Master of Laws. She was appointed as the Judge of the High Court, Mumbai, in June 2005, and she has been a Judge of the High Court until November 2015, almost 10 years as Judge of the Bombay High Court. She has handled several cases which were widely reported, and in 2006 itself, she had held, along with Justice Rebello, that a government's law to forbid dancers in a bar from carrying on their profession was unconstitutional. Carefully, the judges said, let minors be not involved in the profession. While saying so, I am saying because she is an accomplished expert in human rights and human trafficking. She has spoken in several conferences and she has addressed on the use of technology to protect children and to prevent human trafficking. Her sensitive feelings about gender sensitization, human rights, human trafficking, these are all something which you have to go through. She has probably evolved over a period of 44 years in the field of law, and of them 27 years as judge. She has been instrumental in bringing the shape of the law in several sensitive subjects, and ADR is one subject she deals with. And she is an accomplished arbitrator, mediator, and legal consultant. And it was very interesting to note that she studied gender and law in Warwick University in UK. And in addition, she was invited to the United Nations Office on Drugs and Crimes, UNODC, to consider the protocol on the rights of children of sexual abuse. I'm really amazing to read that her experience in shaping this law, in protecting children, in protecting human rights, It's really great, something we have to speak about it. And she was granted a fellowship in peace and conflict resolution for advanced mediation, and she is as such a Rotary Peace Fellow, and she is author of Tangible Justice, setting out memories of her judicial life and articles. We are very fortunate to have Justice Roshan Dalvi here. Over to you, madam. Thank you very much for accepting our invitation and sparing your very valuable time. Madam, you can unmute.
Okay. Good morning to all. Justice Kumar, Dr. Om Prakash, Dr. Ravichandran, and my friends. Today we are going to talk about the commercial law, and therefore I will not think about my human rights approach. This is the commercial rights approach, and I believe that I have got an edge even on the commercial field. But never mind that. You have had a fine discourse from Justice Kumar about how the CPC, the Arbitration Law, the Commercial Courts Act merge. And this amalgamation is what has to take India forward. I would say that each one of us, lawyers and judges, must uphold the law. And these are the laws for the commercial world which we must uphold, beginning with, as Justice Kumar said, the various adjournments which are endemic, ending with a short, precise, concise award in arbitration. Now, since you want to know about arbitration and my topic is arbitrations today, I will be telling you about how these arbitrations can, do, and must go on. So we know that it is an agreement between the parties, and then you can follow any procedure, etc. I would like to tell you, in my experience, what is the best procedure that I have thought we can follow and what we must do to follow that. So if you give me a minute, I'll share my presentation with you. Okay. Can you see the presentation?
Yes, madam.
Okay. So when we begin, we again go through in short the history of domestic arbitration, Arbitration Act 1940, Arbitration and Conciliation Act 1996, which came after the CPC amendments, as Justice Kumar said, and then the most important CPC amendment of 1999 and 2002, Section 89 of the CPC, which gave it birth in a new light. Then we got the Arbitration and Conciliation Act 1996 and the amendments of 2015 and 19. And what I propose to do is to first set out the provisions of the 1996 Act which remain, and not the sections which are amended in 2015 and 19, and to deal with the sections of 2015 and 19 separately, because then we have to forget the 1996 Act for those provisions. So the procedure under the Act of 1996, the Arbitration Act, and I would say this was itself a quantum leap. It was a kind of a paradigm shift from the 1940 Act. Basically would be this: the arbitration agreement. First of all, Section 7, it can be in writing, it has to be in writing, but how would it be in writing? Even by way of correspondence, even by way of an agreement or a clause in the agreement, or even if an application is made and a claim is made and it has not been disputed in the statement of defense, an arbitration agreement in writing can be interpreted. So it's very wide. Parties who want to go in for arbitration can go in any of these modes. Then comes section 16, which is important, relating to jurisdiction. The arbitrator has to decide her or his own jurisdiction. This provision is only in the Indian Arbitration Act. I have read the various provisions of comparative law of the CIR, and they have mentioned that only in India the arbitrator decides his own jurisdiction. Now, when he decides, and if he says, yes, I've got the jurisdiction, he has to simply proceed to the award after hearing the parties. If, of course, he or she comes to the conclusion that I don't have any jurisdiction, he calls it a day. Then there is interim relief, which is important. Section 17 grants interim relief. Now, this provision would be good for various things, not only for the grant of interim relief. Sometimes interim relief is granted under Section 9 by the court. Thereafter, the claim is filed and then the arbitration begins when the reference is made. But if sometimes the judges say, not under Section 9, you go under Section 17, they come under Section 17 and ask for interim relief first. What is really tacitly important about this interim relief is that it allows both parties to make an address. Both parties are really knowing the facts of the case at that time. I would feel that the proceedings, the pleadings must be on record by that time, because then it becomes very fine. The arbitrator can read and come. But even if it is not, the arbitrator can get the gist of the entire dispute between the parties. So this address aspect, which is important otherwise in a hearing, can be under the interim relief application finished up. Okay. Then we go to the real arbitration and the procedure in arbitration, which Justice Kumar said at great length under Section 19, any procedure. So you are not bound by the shackles of the CPC, though you are governed by the principles of the CPC. You are not even bound by the shackles of the Evidence Act, though you are definitely governed by the main principles of the Evidence Act. And there is one judgment of Pradyuman Kumar in Bombay where they have said that it may not be applicable, but the rules of natural justice are always applicable. And therefore, the basis, I would say the basic structure of the CPC and the Evidence Act has always to be followed with the whatever flexibility that the arbitrator deems just and fit, which by and by I'll tell you by giving examples. Then we come to Section 23, the SOC and SOD, statements of claim and statements of defense. Now, I have never understood why a statement of claim should not precede the application for interim relief. Because everywhere you may find a writ petition in all the courts. You file the writ petition and you apply for interim relief. You file the suit and you take out an interim relief application. This is the only procedure. I don't know why after all of these amendments also and so much of lobbying with the government and the government wanting us to have an edge in commercial arbitration, which we have yet not perhaps got, is that the claim is not filed. In one of my matters, when I heard the interim relief application, and that was based upon the Section 9 application that was made earlier, and I made some gave some directional orders for protecting some property. And then the claimant tells me, give me 4 weeks. No, give me 8 weeks. I said, you take 8 years. What do I care? You want to make the claim and I am prepared to hear your claim. And if you want to take 8 weeks, then what signal are you sending out to the other party? So it begins, as Justice Kumar said, from the very beginning, that the psychic and the mental makeup is that you must ask for more time. I've never known why. I once asked the litigant in my court, how many days do you want? And he told me 2 days. The lawyer comes after some time and says 4 weeks. It is that just 4 weeks and 8 weeks are the expressions which are in fashion with the lawyers. But be that as it may, the SOC has to come and then the SOD. These are the 2 pillars. Now you can grant interim relief, you can grant interim award, and you can grant a final award based upon these 2 things. Of course, if there is anything additional that the parties may want to say, even whatever be the compunctions under the CPC, under the amendment of the CPC pursuant to the CC Act, that is the Commercial Causes Act, an arbitrator usually in his capacity always says yes. There's no reason to say no. Even judges never say no because something comes up. But that is when a party comes before the court or the arbitrator and says, this is what I want to say, please, I have not said it. He will say, oh, sure, I'll take it on record. This is not the same thing as saying, I want to say something more, give me more time to say something more. I have not said something more, so you give me still more time to say something more. That is not the purpose and spirit of the legislation of arbitration. Okay. Then section 24 are the hearings, which begin again in the most flexible mode. So we lay down sort of flexibilities that I don't mind. You may say whatever you want here, there, etc. And we give leeways. But we must find the truth. To get to the truth, we have to have the basic provisions of the CPC and the Evidence Act in our hearings. And the default of any party. That is also just like the CPC. When we grant ex parte decree or we grant or we dismiss the claim. So if the claimant doesn't come, you dismiss the claim. You may even continue with the counterclaim and grant the counterclaim if there is any, or you may call it a day. And if the defendant doesn't come, that is the respondent doesn't come, then you have to, on whatever evidence that has been led, give an award. So this is really a very salutary provision. It allows the arbitrator to finish up the arbitration upon what is really before the arbitrator, because parties who want to say things do say things quickly. It is only thereafter that they delay when they come to know that delay would help them. Then comes the actual hearing. So the expert under section 26 may be anyone. It may be a chartered accountant, it may be an RCC consultant, whatever it is, and an expert can be appointed. Now there is a kind of a catch in this. When an expert is appointed, and sometimes parties needlessly apply for an expert. In one of my matters, which is a kind of a suit for accounts, the party applied for appointment of an auditor. Now he's carrying on his business and he has got every right to have his accounts audited. Once it is audited and the auditor's report comes, it can be taken into evidence, subject of course to the auditor who is the author of the document, proving the document, so that he will be cross-examined. But that they don't want to do. So what they do is they tell the arbitrator, you appoint an expert, you appoint an auditor as an expert. But why would I appoint an auditor if you don't have to audit your accounts? You have not audited your accounts. So you see, these are the catches. And then a kind of an experienced arbitrator would know where it lies and not appoint such a person as an expert, because once appointed, both parties will be able to cross-examine him or put questions to him. The next is the court assistance. Now, this is sometimes important because we may go through parties who may be private parties not wanting to come because of their personal other litigations, in which case the arbitrator cannot enforce the attendance, and therefore the court can then issue a summons and call the party who can be cross-examined and examined. Documents can come up that way. But court assistance sometimes is required for government documents. For example, income tax records. If there is a raid, if there are income tax records which are filed, and they have to be brought on record. If you've got copies, you have to prove it by secondary evidence. If not, the income tax officer would come and say, well, these are the originals filed before us, and they can be produced on record. Not often is it allowed. Not often need it be allowed, because secondary evidence can always be read. I have rejected this kind of an application because I said there is no need to go to court and waste time. I will allow you to prove under Xerox copy. Now, this is a flexible procedure. The party feels that he has got some documents, copies of which he has, the originals of which he does not have. We know that they are with the income tax authority in a raid or wherever, and therefore we say, okay, original documents, your secondary evidence aspect is finished, done. We have expedited it to that extent. We don't want the Evidence Act, section 65, secondary evidence, etc., etc. But the real document, whether this was a truthful document or not, will have to be proved on a Xerox copy. So we skip a step, and we don't skip the step, which is an important step, where the author of the document would have to come and say that, yes, I've given these vouchers, bills, receipts, whatever they are, so that then they can be accounted for. Then comes section 30, a very different section, settlement. Now, you must not confuse this with conciliation or with mediation. That is a completely different thing which I'll deal with later. But whilst the parties are giving evidence and addressing the arbitrator, by and large, they understand the strength and the weaknesses of their case. And therefore, they may want to settle. In fact, it is good to settle when it's like repairing the roof when the sun is shining. So a party who is feeling that he's got a strength in this case also must settle. And if that happens, the arbitrator can record that settlement, which will be like an award. So that also is a very flexible and a smoothing procedure. First comes the award. And as you know, not much has to be done by you all. It is really for the arbitrator. It must be on a stamp paper. It must be in writing. It must be reasoned. It must be signed, dated, and showing the place of arbitration, because that's where the later jurisdictions would be for challenge or for enforcement of the award. Now, in this award, there are two other aspects. One is the regime of costs, which I'll deal with later because that has been amended, and the interest, which is a very interesting provision now amended, which we'll deal with later, but it comes in this. The next is the termination. Now, anytime if the matter is settled, it can be terminated. If somebody withdraws, it can be terminated. And anything comes to an end, even sometimes on what is called a summary judgment, because now the Commercial Courts Act and the CPC, as amended for the Commercial Courts Act, would be applicable to arbitrations, which are commercial causes. And therefore, a summary judgment is also opportune. Yes, I'm sorry. Can you hear me? Hello?
Yes, madam. Very much, very much.
Yeah.
We are hearing.
Very well. So we can terminate these proceedings at any of these stages, the last of which is after the evidence is recorded and a detailed reasoned order is passed. Detail does not mean long. Detail means with all the evidences that has come up. Okay. Then comes the challenge. So the challenge is under section 34, and that is also a very crisp provision because 3 months and 30 days. So 120 days and you call it a day. Section 5 of the Limitation Act doesn't apply as per this is it. It is now just like the CPC, which has also been amended, which Justice Kumar also spoke to you about. I will not delve in that. The conciliation is a separate thing, and that is under section 61 to 74. When the arbitrator feels that or a person is appointed a conciliator right from the beginning to bring the parties together, to ask, help them to settle, to create options, to give them a nudge, and then to say that this should be the right thing. So there is an evaluation, which is a neutral evaluation, and then there is something like an award, which is otherwise conciliation. But that also is separate. It's not arbitration. So we go on for the arbitrations. Now, under 2015 and 19 Act, it's a completely new horizon. And though it applies now right from 23rd October 2015, 2 weeks before I retired, so that when I retired and when I decided to be an arbitrator, I knew that I'm going to be under this act. I read that act first after my retirement. Now, the major amendments of 2015 and 19, which I'll take together, are in Part 1, Section 11. Section 11 is the application for appointment of arbitrator if the parties have failed to appoint an arbitrator as per the agreement. Now, if the agreement says that you follow a particular process, etc., you go to the process committee, etc., you have to follow that, of course, very carefully, very meticulously, and then give notice for arbitration. After the notice, you have to wait for 30 days, and then you go under Section 11. The other party has not appointed an arbitrator. I am appointing so-and-so arbitrator. If there is a sole arbitrator, the court will appoint. If there are 2 arbitrators and they cannot decide, again, the court will appoint. But now, after 2019, there is an arbitral institution which has to appoint. And I don't know in how many states an arbitral institution has been constituted. It should have been constituted by now, but I don't think it is done. And yet the judges appoint under Section 11. Now, Section 11 jurisdiction has become extremely narrow because 1, the arbitrator can decide his own jurisdiction. And 2, under the judge-made law, it has been decided that when there is an agreement, that is all that the court has to see. There is an agreement in writing between the parties. You can't appoint an arbitrator. I will appoint an arbitrator. That's all. It should not take more than 3 minutes. every other application should be disposed of by the Chief Justice or by his nominee. But that does not happen. And in fact, there's a judgment which says that everything will be decided by the arbitrator, even if it is that there has been a kind of an NOC, which generally comes up in many matters, that there is a contract, there is a construction contract, and a part of the contract has been executed. The other part is not being done because there are no machines, etc., etc. Then parties agree that, okay, you pay me off, and if you pay me off, we'll call it a day. So I give a no NOC, no objection that you can have another arbitrator. This also formally, when the courts were looking up. But now that is not required, the arbitrator can look it up. And therefore, Section 11 is a narrow, compact case legislation. Okay. Now, the backbone of the new act is Section 29A. And Section 29A, I would say, is a whip upon the arbitrators as well as the lawyers. It shows actually what Justice Kumar said, that you had so much discretion and you misused it. Arbitrators who are judges as also lawyers, and lawyers who are appearing before the arbitrators as lawyers. All of them have misused it. It is like the less than the minimum sentence under the IPC, which discretion has been taken away under the new Criminal Amendment Act of 2013 after the Nirbhay case. Now, you can't give less than the minimum sentence. Similarly, you cannot have arbitrations more than 1 year. Now, under Section 29A, there is limits mentioned. Perhaps this is the only legislation in the world which has this dubious distinction. This is one thing I'm not proud of, just as I was proud of, say, Section 16, which is the only legislation in India. This shows, and the world knows, that this was not done, which should have been done. And as Justice Kumar said, sometimes you can dispose it of within 1 day. I'll tell you that I did it in one matter. But basically, under Section 29A, we have got 6 months, which is a very fair time to dispose of arbitrations. I have disposed of several arbitrations within 6 months, if not 7, 8 months. Now, this is the recommended period. But knowing that we are slow tortoises, the government has given us, the legislature has given us still further 1 year. 1 year is the allowed period. Those 6 months is the recommended period. So 1 year you go on doing what you want. Then there is an amendment in 2019. 1 year you count from which date? Formally, we were counting from the date of reference. And that is how within 6 months I have disposed of, I said. But thereafter, there is an amendment. Oh, after the defense is filed. Because in this 6-month period, 4 months are taken up by the lawyers to file the claim and the defense. And then 2 months are remaining in which we take the evidence, we record admissions, denials, whatever, and we dispose of the arbitration. So we are given some more time. We means the arbitrators. Now, the arbitrators who are slow coaches have got some more time. So from the date of the defense, they count 12 months. So actually, it comes to 18 months or so, more or less, at least about 14 months. Now, as if to say this is not enough, if the parties agree, you can still further extend for 6 months. Just see the leeway which has been given, knowing how much work the arbitrators and lawyers do and how efficiently, expeditiously, and quickly. Okay. So now the question remains is, okay, you both consent that the arbitration will be extended, but I may not consent because I have not made any delay in the arbitration. I don't want to be held on like this. If that happens, then thereafter you have to go to court. If the arbitrator agrees and gets the 18-month period and yet cannot finish, I don't know how, I've never ever had such an arbitration. But if that happens, then you go to court. And now comes the bigger whip. The court can terminate the services of the arbitrator. The court can say out of 3 arbitrators, 1 arbitrator is removed because that arbitrator is causing all the complications because he's either not available or he's ill or whatever it is. Then he cannot be an arbitrator, obviously. And the court may even reduce the fees of the arbitrator. What a shame. I don't know how fees could be reduced, because if the arbitrator works efficiently, there is no question of doing that. And if he does not, he should say, okay, please go away, I have not been able to work. But to take reduction of fees, I don't know how they take. But this is, and this is the backbone. Within this time, if you cannot finish, there is nothing like an arbitration. Because how does it become an alternative dispute resolution or an additional dispute resolution or an appropriate dispute resolution for commercial cases? If you take years upon years, to do that. I know about some judges who have said, oh, no, it always happens like that. It doesn't always happen like that. From experience, I can say that. Okay. Then a very salutary provision, a very sleek provision. Section 29B, fast track procedure. Now, how many people follow this fast track procedure, I do not know, but I got an arbitration under the fast track procedure. So parties came and told me it was a big time arbitration. There were amalgamations of some companies. There was another company which was a construction firm looking over, having a watching brief, and they were going to merge, etc. And a lot was done. But for certain things, they just could not agree. So they said, we'll go to arbitration because we've got an arbitration clause. And they came to me and they said, there's no need to record evidence of all of this. We will argue on this and you decide. I said, fine. Now, even for that, what they said is, I will argue on Monday and he will argue on Wednesday. Why? I said, if you want to argue, it's like a matter coming up before me. So both of you are there. You give me the papers in advance. I will fix one date. Both of you argue on that date because it is a fast track procedure. I'll give you a word. And that's what they did. So we met at about 10 o'clock in the morning. We went on till about 5 o'clock in the evening, when even I was really famished, without any recess. We finished up both the arguments, and I even started after 5 o'clock dictating the award. The only thing that happened was that even I did not know how quickly I could go, and therefore I didn't have a stamp paper. So I told them, okay, come tomorrow to my chamber and collect the award. And I got the printed on the stamp paper and gave it to them. Now, we will deal with this kind of an aspect when we deal with the fees of the arbitrator under the fourth schedule, which I'll come to a little later. But keep this in mind, that fast track procedure can work, must work, and you must take it up before arbitrators. You can have fees by agreement. In that case, they agreed to pay me the fees under the fourth schedule. So for one day, I received that fees and it was a huge matter. So we went up to the capping limit. But it doesn't always happen like that. That was a freak case. So we can have an agreement that, you take 1 day or 2 days and you charge this much. It is a package deal. We'll come to that aspect also a little later, but I'm giving you this as a backdrop. Now, after this procedure is there, either with evidence or without evidence, how much evidence, all that, and the time limit is fixed, we come to the award. Again, Section 31, award, I told you what was in the 96 Act. Now, in the 2015 and 2019 amendments, 7B is interesting. Interest on award can be 2% more than the commercial rate of interest. Now, this is a whip upon the defaulting party. Every time the party defaulted in payment of money, he knew and his lawyer knew that so what? There will be interest at the rate of 6% or 10% or something like that. We will still make a profit. Now you cannot make that profit. And therefore, a defaulting party will have to pay 2% more, which need not be in the award. We don't have to mention that because the legislature mentions that. There are parties who tell us to mention that safe side, for the sake of execution or even at the time of challenge. So we mention it. It's like 448 of the Criminal Procedure Code. Sentence already undergone. It has to be given a go by, but they say, please mention that. So we mention that. And that is interest on award. And then there is a regime for costs. Costs have to be compensatory. Compensatory means made to compensate a party. So either you grant or you don't grant. If you don't grant because both parties have had an argumentative case, fine. It is on arguments and you have accepted one or the other of the arguments. But if it was an open and shut case, if one party was really defaulting, then the entire cost of arbitration, I have told in one matter, you tell me my fees, you tell me the lawyer's fees, you tell me all of this, and I'll add it up. And I granted that for enforcement. So that is mainly the regime for costs. And if every arbitrator, even every judge in the country would grant compensatory costs to actually compensate, most of these delays will go by the board. Okay. Now comes the enforcement of the award. Section 36(2). Again and again, there is lobbying power. And again it has been amended. Formerly, there was an automatic stay. Then they said no. After 2015 amendment, no automatic stay. You have to make a separate application for stay, and the stay can be granted on whatever terms. So generally, it is granted on deposit or security for costs. Deposit of a part of the amount or the full of the amount. Okay. Now, the question arose from what happens to arbitrations before 2015. And it was said that, of course, it will apply because it is procedural. Now, no, the legislature said it is not procedural. So the legislature again amended, brought in section 87. Then 87 was challenged, and the constitutional validity as it was seen. And it was held that it is arbitrary, and therefore it has been set aside. And now there is a new amendment under 36(2) for enforcement of the award. You have to give under all the matters after 2015 at least, and I think now only those matters will be remaining, because you can't possibly have a matter from before 2015 in 2020 end. Now you have to grant conditional costs, and rather conditional stay only if there is fraud or corruption. Then there is a new amendment under the ordinance. It will soon become an act. The ordinance is of 4th November, that there would be unconditional stay. Okay. Then comes section 42. 42 is confidentiality. It goes without saying that proceedings are confidential because we hold it in our kind of chambers or in a room, but that is what is said in 42A. And in 42B, no suit against an arbitrator. It would be an ill day for the country if people started filing suits against their chosen judge. It is like a church proceedings, and therefore there can be no suit for work done in arbitration. Subject, of course, to section 29A, where you can apply for termination of the arbitration because the arbitrator does not give dates or cannot come or whatever that is. Then comes part 1A, a very new part. Nothing has happened so far, though it has come in 2019. We are at the end of 2020. Arbitral Council of India. So now there is a council. That council consists of the chairperson, who is a retired judge or a retired chief justice. They will conduct proceedings, they conduct workshops, for example, like this one, seminars, etc. They will have the say on how the arbitral institution works. That is because the judges will now not work under section 11, the arbitral institution will work. So it is an institutionalized procedure for the entire country. So there will be one council at the top, and in all the states there will be arbitral institutions. I don't know when it could be appointed because they should have been appointed by now. And this arbitral council, part 1A, consists of sections 43A to M and consists of various things that the council would do. Then we come to the schedules, extremely important. No act has got so many schedules. Only the Constitution has many schedules. Now let's see the schedule. 4th schedule is the ad valorem fees of arbitrators. Now therefore, this also deals away with that melee of delay. If an arbitrator feels that without working, which is really bad, but without working and giving a date, I'm going to earn, that regime has gone. Therefore, the arbitrator will be getting ad valorem fees. And with dignity, the arbitrator would tell the parties that I will be paid under Schedule 4. Nobody can dispute, nobody has disputed, at least in my arbitrations. But we must read this Schedule 4 along with Section 29A. Now just see the provisions. 29A sets out the time limit. So it is 6 months recommended, 1 year allowed, with extension 18 months. Now 18 months after all of this pleadings are complete, and then you go to the court and ask for still further 6 months. Okay. Now if an arbitrator is like me and finishes up within 6 months, the arbitral fees which are ad valorem will have to be paid within 6 months. Why would such an arbitrator, for the default of one of the parties who always delays, be not given his ad valorem fees early? And now how will this ad valorem fees be paid? That is another important thing. If the arbitrator says, I want to be paid in advance, the parties will say, we don't know whether you will go on with the arbitration or then we will have to appoint another arbitrator, so we can't pay you in advance. Very fair. If the parties don't want to pay and want to pay at last, the arbitrator will say, I'm not going to read the papers and conduct the arbitration unless I have been paid. So an ideal thing is to say half in the fund first and half last. In between, we don't talk of fees. We do our work, we perform our duties, we discharge our obligations. All of us, arbitrator, lawyers, and litigants. And then we think of fees, first and last. Now this works very well, at least with me, this is my personal experience. Then comes the High Court rules. Now in 2019, we had our Bombay High Court rules. So what they said, that whatever is in the claim as well as in the counterclaim together, though they will be tried, there are two different suits, they will be tried together. They may be tried separately for separate evidence, but you count them. Now there is a capping of fees. That capping of fees comes at the end of Schedule 4. So when there is a capping, and if the claim itself runs so vast that a cap is reached, the arbitrator cannot charge for the counterclaim. The counterclaim may be for even higher amount, but there is always a limit. And as Mahatma Gandhi said, there is enough for our need, but not for our greed. But now then what happens is that the arbitrator feels that he has got to conduct a separate suit. So what does he do? He has to amalgamate two, and therefore if the capping is reached, he cannot go beyond the capping. There is a Delhi High Court judgment of 17 July 2020, which says that this capping is as per the amount which is laid down in Schedule 4, if you see the first column, plus whatever is in the second column. So that takes generally the care of the counterclaims also. But several of the arbitrations that we have done before 2020, counterclaims could not have been charged. But this is it. Now the importance. Let us understand the importance. Not only that the arbitrator will now not delay. The capping is say 30 lakhs. So if you finish the arbitration in one day, you get 30 lakhs. If you finish in 10 turns, you get 3 lakhs each. If you finish in 30 turns, you will get 1 lakh each. So it comes down as the matter progresses and as you don't finish the arbitration. You're not going to be able to earn more as an arbitrator. Now the lawyers want to delay. As Justice Kumar said, that is endemic in our system. Lawyers also, therefore, can charge ad valorem fees. Lawyers also can charge by way of a package deal. I will tell you about this package deal when we deal with the case management aspect in arbitration a little while later. But Schedule 4, therefore, lays down all the limits, and it has to be read along with the limits of time. Okay. Then fifth schedule, arbitrator's relationship with the parties. Of course, if there is any relationship, we don't take it up. If we get an arbitration of a company and we own the shares, we don't take it up. We've got some relationship of a shareholder. Then the sixth schedule is disclosure of showing time available to the arbitrator. Extremely important. Because if the arbitrator has got 35 arbitrations, there is no time available to him. He must disclose that. She must disclose that. And then the parties will say, oh my God, 36 are my arbitration, we don't want you. And that is how it should be. And the arbitral council and the arbitral institution must therefore widen out that base for the good of the country, for the good of the system, and for the good of each of the litigants. So that all arbitrators who are on the panel, all arbitrators who are arbitrators, lawyers as well as judges, would get enough for that time. And now what will be that enough? That will be again given in the seventh schedule. Yes, in the seventh schedule, disclosure of interest of arbitrators. Now, the arbitrator has to disclose his interest. It goes without saying. There are some 19 items. So if you fall in any one of them, you can't be an arbitrator. The litigant as well as the lawyer would also see that. Now, one of these items is that no arbitrator can be appointed more than 3 times by a single firm or by a single individual. So you may have your favorite arbitrator, but you can't go on appointing him for 40 times. That is the thing. Now, this principle must therefore be applicable also to the arbitral institution and the arbitral council, because the statute has to be read as a whole, and the spirit of the legislation has to be seen. And the spirit is that if you have 3 arbitrations, at present it's enough. You finish one and take the 4th one. You finish the 2nd and take the 5th one. If you do that, it becomes extremely good, and then there is no need for this kind of delay. One by one, you finish up everything, and always take more. Then you go to the 8th schedule, which is the latest schedule, which also shows the same spirit of arbitration. Qualifications and experience of the arbitrator. Now, 10 years experience, in short, is what is required. 10 years experience as a lawyer is required to be a judge, also of the High Court. But not that they are appointed always after 10 years. They are appointed after many more than 10 years. And 10 years in what? 10 years as a criminal lawyer is no good for an arbitrator. 10 years as a lawyer for a motor accidents claims is no good for an arbitrator. 10 years as a trial lawyer or a trial judge, having tried civil commercial suits. That's how it should have been. And that's how it is meant to be read. So that you can have arbitrators who have got the expertise of a commercial matter. Okay. So now this is an extremely sound and all-pervading legislation. It is for us to make it a success. And I would say if any of the lawyers or arbitrators do not do that, they are really anti-national. I beg your pardon. Now, therefore, I would say in today's arbitrations, there should be these steps. AAMIEAA. If you remember that much, everything gets covered in this. AAMIEAA. A stands for address. Here the address. Now, address of the parties comes essentially in the interim application, and almost every arbitration, at least in Bombay, has interim applications made out. Please protect my property, please tell him not to do this, etc., etc. So why do we have to do this? At that time, both the arbitrator and the counsel will know the matter thread there. Okay. As soon as that is done, the second A, record admissions of facts. I record all the admissions. That means that the arbitrator has to read up the claim and the defense thread there. Find out all the admissions, admissions in the correspondence, admissions of agreements which have been executed. And as Justice Kumar said, what admissions? If there is a chain of correspondence, there is an admission that there is a chain of correspondence. But of course, naturally, if you're going to deny something in your email, in reply to the earlier email, I can't say that you have admitted that fact. It is denied. There is no need to mention that. It is such a stupid thing to mention that. I tell them I'll mention it once, that whatever that we are taking on record then is admitted so far as the receipt is concerned, but not the contents. Because the contents will have to be proved separately, as was decided in AIR 1983 Bombay 1, UTI versus Berlier. That case, it rules the roost even today. So we record the admissions of fact. Then M, AA is finished. Now M, mark the admitted documents. This narrows down the dispute. You mark all of the admitted documents. I mark all the claimant's documents as A, B, C, D, and the respondent's documents as 1, 2, 3, 4. So let there be no mistake, nothing. Then we have to, when we have to return the original documents, all alphabets go to the claimant, all numbers go to the respondent. Simple. Now, after you have marked all the documents, the unadmitted documents will remain. If they are unadmitted documents, they would have to be proved. They would have to be proved under the basic structure of the Evidence Act. That is, by direct oral evidence of a particular document, or by secondary evidence, private documents or public documents. Public documents can be proved by certified copies. Public electronic documents we have got now, because electronic documents have to be proved under Section 65, Bashir versus Amar, and thereafter when that was further gone through. But what happens to electronic certified copies of public documents? Electronically certified. They are essentially certified copies. They are public documents. And therefore, you don't call the public person, especially in arbitration. You take it in and mark it as your document. Okay. Now, this may be subject to cross-examination and subject to proof also. Then comes the framing of issues. Having done this much, you can narrow down the issues. So then only the issues which are really disputed will remain. You frame 1, 2, 3 issues so that you know that these are the subtitles of the essay. And therefore, there is clarity of thought. And then you don't muddle up the feelings. The lawyers will understand, the arbitrator will understand. Okay. Then you record the oral evidence. Now, record the oral evidence is a thing in the mind of everybody that recording of evidence must be there in every single civil suit and every single arbitration. That's not so. In so many matters, parties may themselves tell the arbitrator, I don't want to record the evidence. All fine. But even if the arbitrator has to record the evidence, for admitted documents, for admitted facts, you have to tell that this is what I will deal with now that the documents are on my record. And whatever is required only for that oral evidence, wherever necessary, can be added. For example, if there is a damages claim, then of course you have to prove the damages. through whichever witness that comes along. And that evidence would have to be recorded. Again, how do you record that evidence? The arbitrator can record a memorandum. I write down sometimes by myself, and sometimes the stenographer now does it on those fancy boards in the sophisticated arbitration rooms. So that I record a memorandum, I tell them, keep on asking for one subject all the questions that I'll tell you to stop. And then I take down in a narrative form whatever is the substance of the evidence. In many matters, this has worked very well. Parties have accepted and they have felt that their image has improved, actually. Because otherwise, if you're going to record question, answer, and you record 1,000 questions, you don't know which 35 questions are the important questions. But if you are going to record a narrative, and then if there is either a misleading question or a misconceived question or a misleading answer, then you can record that by way of question and answer. It becomes very explicit. So that is how a usual procedure in arbitration would be ideally done. Then comes the stage of hearing of arguments. So you hear arguments. Of course, you have to give notice to, you have to give hearing to both the parties. Hearing can be either oral or written. It can be oral in depth and points in writing. Or it can be detailed written arguments and quickly going through those arguments orally. One of these two modes would serve the purpose entirely for complete right of natural justice. And then the arbitrator would have to pass the award. And as I told you under section 31, how you pass the award? In writing, signed by the parties on a stamp paper with reasons, interest of 2% more and costs. That's the award. Now that is the final award. There can also be an interim award, which I told you later, if there is a part of the claim which can be disposed of. Now an important thing which is not in the legislation, but which can be done by reading the CPC and the Arbitration Act together. Now consider section 89 of CPC, the alternative dispute resolution modes, arbitration, mediation, conciliation, lok nyayalaya. Now consider the section 30, settlement, and then conciliation proceedings after section 61. So we've got the Arbitration Act, which is the Arbitration and Conciliation Act. Conciliation would include mediation, because mediation is a little less than conciliation. Conciliation is when the mediator goes a little further and actually gives out what should be the agreement between the parties, and not only allow the parties to settle. So what we do is we combine the arb and the con. Now, how do you combine that? It is in the legislation, but you have to do it in a very fine mode. Now, suppose the arbitrator begins with settlement. Oh, come on, this is a commercial dispute. Why don't you settle? I will help you to settle, etc. And he actually mediates, which is very good, but he mediates. And the parties don't say that, okay, you be the conciliator. So he may mediate. If they agree, it's fine. If they don't, he has to give the award. He has to take the entire proceedings through. What happens is that in this mediation, parties are entitled to have a caucus. Caucus is that the mediator can hear parties together as well as separately and know the inside story. But this inside story, if the mediation fails, cannot be relied upon because it is not on evidence. It is not what the parties have told each other and put on the pleadings. Therefore, an award must be as per the substantive law and a flexible procedure under the procedural law, correct? So therefore, in the award, there may be a mistake and the arbitrator may take into account what one party has said. This is treading on very strange, very fragile grounds. And I think that should be avoided. What I do, and perhaps what I can leave to you, is that I hear the arbitration in the beginning by following these 7 modes, AA, MIE, AA. I pass the award and then I keep my award ready. I call the party to collect the award. Generally, the parties are from Bombay, so it's okay. If the parties are from outside, I may not be able to call them. I may send them by registered post. That's fine. But when the parties come, I keep it in the morning. And then I tell them that you paid my fees as an arbitrator. I am not going to charge you any further fees. I am prepared to give you 1 whole day. I am prepared to mediate because this would really bring about good business relations and your business relationship will be maintained. If it is a family property dispute, their family property relations will be maintained, etc. So they agreed. Now they have told me everything, and everything is very clear in everybody's mind. I have made the award within a few days of the hearing of, by the parties. So they will not go into the law. They will not go into the facts which I know. They will only tell me what is additionally to be told. Now, sometimes there are those sister concerns. Sometimes there are partnerships between some directors of the companies and in a given company. Sometimes there are matters between, say, the partners, and there is a construction contract. So between the flat purchasers who may have to be taken care of, which can be arbitration between the parties. Arbitration will be only under the agreement between the parties. Otherwise, we would exceed our jurisdiction, which we cannot do. But it can always come in mediation. And therefore, then the parties will feel, because by then, by and large, parties and lawyers know almost which way the award is going to go. And the award is ready right before them. Okay? So, the parties will tell what has not been told. And if that can make them come together on that day by sitting together for many hours at a time, it will be an ideal thing. And I tell them, if you come to any conclusion like this, any agreement, we will draft the agreement and I will tear out my award. And if you don't do that, I will serve the award. So after that one day, at the end of the one day, parties know where they stand. And one thing is absolutely done and clear. Now, what happens is that all matters don't get settled even after all this effort that we put in. But I feel that when I do this, the germ of settlement goes in. Parties begin to realize. So when they see the award, they know one party will have to enforce the award. One party will have to challenge the award. So they are going to meet after some time. And this is where they will take off again. Because then they will have given it a thought. We have got this award, we have given all this evidence. But this is what was said. We have come so close, but we have not gone far enough. So they come together. And this, I think, would be truly an alternative dispute resolution in a commercial cause and in a family property matter. These are the two types of arbitrations that we have. Okay. So now what we deal with is, this is really case management. Management of how efficiently you deal with a case. So what is case management? In England, under the Lord Wolf report, Lord Wolf said, practitioners and judges becoming better at what they do. Now here, practitioners and judges have to become arbitrators and lawyers in arbitration. They achieve the same end with less resources and in less time. Now time is fixed by the legislature. Resources are the fees that you pay, the room that you set up, etc., etc. But if you're going to do it quickly, everything, all the costs come to an end, come to becoming less. It is case management in arbitration. And this results in these two things: improving efficiency, reducing delays, and cutting costs. Now, when you're cutting costs, generally the advocates feel, oh my God, what about me? What about my fees? Please, that is only a complex. And it is an inferiority complex. You think you can't do any better, but you are capable of a lot more if only you have the confidence. You must say, I can and I will. And then what happens is, the lawyers will say, even I will charge fees ad valorem. I will charge per package. Look, if you want to finish your arbitration in 6 months, I will charge you this much and give you in 6 months. If you don't, I will charge you per day, but it may come to more than this. Parties will always agree to pay even a little more to get the award quicker. And they are commercial parties, they are business people, they know what it is. So now, a little outside the law, the co-curricular work that I might want to tell you. One is, what are these principles? These are business principles that we invoke in arbitration. One is the principle of paradigm shift, which the legislature has done. The Arbitration Act 1996 and 2015-19 are a quantum leap. Now 40 is forgotten, and therefore we have to go by all these parameters which are laid down, where the best of everyone is called for. Section 11, appointment. Section 16, jurisdiction. 29A, time limit. 43A, arbitral counsel. And all these schedules which I told you, which lay down these parameters. It's a paradigm shift. Then there is non-value added items. Now, little applications which are made, this is for amendment, etc. Now, amendments have to be allowed. It can be allowed even in suits. I always allow amendments. What is wrong? The parties have said such rubbish in the beginning only, so they will say some more rubbish now. It's okay. We'll read this. We are used to that. So, those non-value added items have to go by the board. Suppose the claimant dies, his heirs have to be brought on record. Just an entry in the arbitration is enough. There is no need for any application. These are non-value added items. And therefore, under the procedural requirements, 19, follow any procedure. 29B, fast track procedure. All this is fine-tuned. Then the core competence. Core competence today, we have domain lawyers, for domain arbitrators, for example, engineers, for example, architects, RCC consultants. They know those part of the things which lawyers and judges don't know. Our training is different. But if you are going to have lawyers and judges, then trial lawyers and trial judges. People who are dealing with trials are the ones for the commercial court. And that should be in Schedule 8 or is meant to be, implied to be in Schedule 8. Then comes the decentralization principle. You decentralize. Section 11(3)(a), you give it to the arbitral institution. Part 1A, arbitral council. Schedules 5 and 8, where you have to have arbitrators, but not one arbitrator just because I like his nose. It's not like that. You have to go to other arbitrators who are on the panel and deal with every one of them. Each one has got his own strengths and weaknesses. So you decentralize the procedure. Then is the next principle, the corporate principle, blame storming. Now, this is not blame sharing. This is blame storming, like brainstorming. So the legislature has done blame storming. Where does the blame lie? Justice Kumar told you where the blame lies in so many matters, adjournments, this, that, arguments, whatever. This has resulted in these amendments. So after doing this blame storming, we have got this very neat legislation, which we should really uphold as one of our great laws. Then 2, time management. I don't have to go into it, but there is always time management, and that is given by the legislature also, so many months, so that you make your schedules. You give your, under section 24, you give this thing. Not everything that has to be done in the beginning because it's never maintained in India, but you have to say that these are the dates and they are written in stone. So these are the directions of the arbitrator. Then the principle of procedural simplification. Very nice. Whatever are the roadblocks, if any, in the CPC, in the Evidence Act, deal away with them. Do away with them. I'll tell you 2, 3 which I have come across and which I will share with you separately. So under section 9, it is simplification. Then the next principle, team. TEAM. Together, each achieves. So if you have dedicated lawyers and judges, they must work from 10 to 6, 11 to 5, whatever. They cannot work. In Bombay, there is this new style that I will work from 5 o'clock. How can you start arbitration at 5 o'clock, then you finish at 7 o'clock, and then you go on giving 35 dates, and then you say it doesn't finish for 2 years and 3 years? You have to go on, at least if not day to day, which we do day to day. Sometimes I give 4 dates right in the beginning after a long time, so that they know, and they come on these 4 dates when there is cross-examination in a heavy matter. So that then you have this dedicated lawyers. You have lawyers who will work for the whole day. You have arbitrators who will work for the whole day only in that one arbitration and not put up an entire board of arbitrations. I'm told in Telangana, there was one arbitrator who puts up a board of 65 matters. I mean, I don't see how any one matter can go on, but that be it. Then there is an OODA loop. OODA is observe, orient, decide, act. The resultant new legislation is the OODA loop. The legislature has observed how the arbitrations were going on. It was a shame. Then it has oriented. Now we must have a new legislation. No, we must lay down all these parameters and all these ambits. Then they decided and they acted, and we have got a new act. Then there is this package deal. What is the package deal? The evidence and the fees. So the arbitrator gets under this package under Schedule 4. The lawyers also can demand as much as they command. So any lawyer will say, well, I'll charge you 3 lakhs of rupees if you want an award now for that 1 day of hearing. Fine. If you can command it, take it. But start that so that you have a package deal. Now, a very good example is an example of a travel agent. Some years ago, you may have forgotten also now, but these travel agents were only booking our tickets. There was no internet at that time. And we used to go to travel agents and we used to send our secretaries to the travel agent. Then they used to book tickets. Then they started booking our not only flight tickets, but also the taxis. Then they started booking hotels. Now they've started booking tours. So we can give to a travel agent everything. The entire holiday. I want a holiday for 15 days. In this place, this is my budget. He makes a package for you. He charges you for the package. Lawyers are more intelligent, more educated, more erudite. Why can't they charge a package? You must find out what the matter is capable of. Charge, but deliver the goods so that you earn, but you earn by doing good. That is the last of the corporate principles in arbitration. And now, as I told you, I'll come to it later, the removal of the roadblocks. Some of the roadblocks are created in evidence. For example, pleadings. I take the pleadings, the claim and the defense as evidence. No matter what rubbish is there, I don't even try to redact or I don't even try to scratch off. I keep it there. You want it, I appreciate. Okay. You have got your own dignity, I've got my own dignity. But I'll take it as evidence. There is no need to repeat. If you have got something additional to say, by all means, you say in a separate affidavit. But otherwise, I will take this as affidavit of evidence and you'll be cross-examined. But the lawyers want to file the affidavit of evidence and want to cross-examine again, and then we allow them. But somehow it gets settled because a little less comes in the next affidavit. Then all original documents. It's very important, I feel, that all original documents must be brought in arbitration every time. Quite often, the other party can take screenshots. The other party can immediately take inspection. And everything gets finished in my chamber itself. So there is no need for further dates for we want to take inspection, and all of these things can be avoided in many matters, not in all matters. Then there is simplification of proof of documents. Like I told you, for example, the documents are with some other party, the Xerox copies are there. Instead of calling upon another party and he doesn't come and telling the court, please call him as a witness to produce documents or any such thing, take the Xerox copies as evidence, as if to say there is secondary evidence proof, and prove those documents. So ultimately, the truth comes on record. The party who has signed the Xerox copy will have to come and then he will be cross-examined. So a stage can be over. So all seemingly genuine documents, I take them in immediately because this is a very genuine document. Now this is old. It was like this and after that, this was the agreement. Okay, take it on record. Documents in a group, sometimes they are relevant. If I had an arbitration of a leave-in license and then there was something about the fabrication. So I said, all right. Or the rent receipts which were earlier given, produce. One was stated to be fabricated. I said, produce for 3 years. You cannot fabricate 36 rent receipts. You cannot forge them. The truth comes on record. So these are the leeways which any civil trial judge or a lawyer would know how to go through. And then we can say that the Evidence Act and the CPC does not apply. We have got this added sort of leeway to do things. And that is how the best arbitrations could be carried on. So as J.R.D. Tata had said, there's a joy in having done something as well as you could and better than others thought you could. Thank you. Now,
Fantastic, madam. A very detailed insight about the entire arbitration proceedings. And we have some queries which has come up. The question is whether during the arbitration proceedings, can a party in the midway discontinue the arbitration?
for a valid cause and reason, yes. Suppose the arbitrator does not give dates, suppose the arbitrator delays, the party is not going to go on suffering the arbitrator for all along. So then there would be termination of arbitration proceedings in section 32, and we will have to go to court to have the services of the arbitrator terminated. Of course, if they settle also, they can terminate it. And
during COVID times like now, whether the proceedings will be happening in video conference and the evidences can be sent by email, whether it is acceptable norm?
See, the affidavit of evidence we take on email, cross-examinations would be going on. There are certain there are certain videos relating to ideal cross-examination also. I may be able to share something with you of a lawyer who was a Queen's Counsel in England, and who says that I put in 4 blocks on the online video conferencing. One belongs to the witness, me, the other side lawyer, and some others, where the documents, etc., can be displayed. And that also can go on. So we are doing that also. But by and large, during COVID time, the online arbitrations have been for applications where they only argue. And that goes on very well. Cross-examinations, we have to sort of, with the same party. I would say that on the first day, we have a trial cross-examination where we will not record much, but the stenographer is available and all, so that we know. And then the parties naturally feel more comfortable.
This is a question to former Justice N. Kumar. Lordship, this MSME, the small scale and medium sector, normally arbitration normally is meant for bigger companies, larger corporates. How does it, reach the MSME who cannot afford this? Is there a very economical way of conducting arbitration? Of course, there is a scheme promoted by the government. It is called Samadhan for MSME, but it seems to be not working very effectively. Yesterday also I had a workshop with the arbitration sessions. The concern was whether the tier 2 cities, rural areas, the arbitration doesn't reach them. How do we bring the awareness about this arbitration, especially in the small scale sectors?
These constraints are there. For example, in Karnataka, we have an arbitration center set up by the High Court. There, comparatively, the fee charge is very less when compared to arbitration which is done outside that forum. Now, for example, the what is that? Bombay Stock Exchange and National Stock Exchange. There, the fee is very, very nominal. If all the small case industries can have an association of theirs and have an arbitration center there, they can extract fees. It could be done. Not that everybody wants higher. There are arbitrators who arbitrate and work not for the sake of money, but with the love of arbitration work. Only thing is you have to choose such arbitrators. People also should give up their I want a Chief Justice, I want a Supreme Court judge. I don't know what. If that is, you have to pay for it. That's all. You must have a good judge. Don't go by the past designations. Go by the.
Another question was whether amendment to section 34 will bring a big change in reducing time delays, declining petitions.
No, automatic stay. If that provision is enforced, half the cases are filed. Nobody wants to deposit the money and then contest the matter. He's a businessman. I think for them, time is more valuable than money. Or at any rate, as the member was suggesting, they will open the rights and sit and settle the matter after the award. That's also permitted. But in the end of the day, it is the mentality, mindset of the litigant and the judges. That's where we have to change. The arbitration atmosphere. We have to develop what's called as arbitration culture and culture. That is where some education is required.
Lordship, nowadays the company secretaries, the chartered accountants, and engineers also are getting trained as negotiators and arbitrators. But if you see, their proceedings are all different. It is not the way it has been conducted by the judicial fraternity. Is that okay, right? All is well.
They don't go by qualifications. colleges and qualification. There is no indication of their ability. For example, an accountant can become a lawyer. But the question is, what is his priority? Because he's permitted to appear before a court to think that he is competent in a misnomer. But a person who is not a proper training can become. So we are only going by the status and the qualifications. Therefore, all this problem.
And Justice Roshan Delvi, there is a question for you. Why not introduce monetary threshold for Section 29B?
Why not introduce what?
Monetary threshold.
Yes, see, under Section 29B, which is the fast track procedure, parties can agree upon the arbitration fees. So, Schedule 4 is not applicable if the parties don't want it. And of course, if the arbitrator agrees. And in fact, I wanted to answer, if you could have permitted me, for the small scale industries. You say that the arbitration should reach out to them. Now, there are many arbitrators who would want to arbitrate, not for free, but for less. And that can be under 29B. So those small scale matters and matters which are of small nature, they can be by a fast track procedure. And the parties may themselves agree and with the arbitrator that we will pay you this much fee. And the arbitrator will say, okay, I will give you 1 day or 3 days or whatever. And you finish up the matter. That is an ideal way of doing it. In England, they give only 5 dates of hearing for the biggest of arbitrations. I was told a very big matter of a big site, the airline, went in England and they thought that they will go for months. The judges said, we have read everything. I will give you 2 days. So they said, no, it's impossible. And ultimately, they got 5 dates of hearing. And the award was given. So you see, it is not that it cannot be reached out, but then that small scale and medium scale industry must also be completely prepared, come quickly, tell the arbitrator the facts of the case quickly, so the arbitrator can give an award quickly, and the parties can agree with the arbitrator, this much will be his fee. Very fine. It can be done that way. That is under 32.
Yeah.
Sorry, 29B.
Another question is, why was Schedule 8 scrapped? Why was Schedule 8?
I asked the legislature.
And another question is, can an arbitrator advertise?
No, I wouldn't.
No, a non-judicial negotiator, a non-judicial domain expert, who becomes an arbitrator, can he advertise?
Maybe he can. But I think our mind culture is that we don't. So I would say no.
Participant, any more questions? Lordships are available here. Very rare to get such knowledge base. I think that we will close the question and answer sessions. And Rupa, can you play that video? We have a small video being played from Bcic. It will reach you, madam.
Yes.
Thank you, Rupa.
Thank you.
Thank you, Rupa, and thank you very much, both of you. And I now call upon Dr. K.S. Ravichandran to extend his vote of thanks, and the mementos from BCIC will reach you to your residence, and we will make it available. Thank you very much.
Oh,
once again.
I'm so far away. It's okay.
It's fine. It's fine. Our pleasure. Bombay is not far away. Okay, over to you, KSR.
Both Justice Kumar and Justice Roshan Dalvi, I felt 45 minutes was too short a time for them.
Yeah.
It was a rocking presentation, wonderful, and I enjoyed the whole thing. I think participants would have given whole of their mind attention to this beautiful presentation. Such a value added. I think Om Prakash at BCIC, you have already presented a vote of thanks. So I don't want to take much of your time. But what I'm saying is that we must have a continuous series of program wherein we understand the nuances of this alternative, what Justice Roshan Dalvi was saying, appropriate, and so many words he was using for the same ADR. It was nice. And we really enjoyed the presentation. Particularly, I was so nice. It was about section 19 and section 20. Justice Kumar was explaining such a beautiful language. It was wonderful. And we learnt a lot. The amendments have been brought to our mind once again, including the latest amendment of November 2020. I do not want to take any more time. Just we say a big thanks to both of you for having consented and addressed and being with us for this much time. And we look forward to hearing from both of you very frequently as a knowledge sharing for the members of the BCIC. Thank you very much.
Thank you. Welcome. Thank you, sir. Thank you.
Justice Roshan Dalvi, there is a request. Members are asking whether you can share the presentation
Yes, sure. You can take it.
that I can circulate to my members.
Yes, you can answer. Definitely.
Thank you very much.
No
both of
fees
you.
charged. No fees charged.
Schedule doesn't apply.
Kumar,
Okay,
ji,
bye.
thank you very much. Ji. Thank you very much.
Thank you very much, sir. Thank you very much, madam.
KSR, for making this
Thank
happen.
you.
Yeah, thank you.
And also the BCIC Secretariat, thank you very much for all the efforts.